Morning.
Ms. Perry, we see that you are here, and Mr. Cunningham, you are there. So we are ready for you. Don't forget to unmute your microphones as you begin your respective arguments.
Good morning, Your Honors. My name is Allison Perry, and I represent the appellant, David Lambden, who is the former husband in this post-dissolution appeal. I'd like to reserve 5 minutes for rebuttal, if I may.
Very good.
This issue is, there are three, well, actually only two, well, there's three issues in this appeal. The husband filed for a modification of his $1,500 a month permanent alimony award, approximately 13 years after his the party's final judgment. The final judgment of dissolution of marriage awarded the wife, who was a stay-at-home wife, $1,500 a month in permanent alimony. At the time of the alimony award, she had independent income of $523. The court at that time found that her net need was $1,720 a month, and her gross need was $2,023 a month. In 2013, the husband lost his job. He was in his 60s, and he was forced into early retirement. During the modification proceeding, it was determined that there was a substantial change in circumstances. It was involuntary. It wasn't foreseen. So the court said a modification is justified. During this time period, also, the wife started receiving $790 of Social Security income. And instead of the court examining what her needs were, because and what his ability to pay, the court just said, I'm going to cut his alimony payment by the $790 that she's now receiving in Social Security income. So the court cut short its duty to perform a 61.082 analysis.
Ms. Perry, can you help me with some of the numbers?
Sure.
Your client's claimed monthly expenses are about $3,200. Is that correct?
Yes, almost. Yeah, exactly. Almost.
I had trouble finding it, but does that number include some alimony component?
That is without the alimony component.
It is without the alimony.
Without the alimony
Okay,
component.
thank you.
And that's why he does not have the ability to pay any alimony. Because he is actually running a monthly deficit, because his income, his gross income is $2,924 a month. His reduction since losing his full-time job is $2,638 a month. So his income has been cut in half almost. Yet the judge did not even look at his ability to pay, which is legal error.
The judge, at some point, I guess it was after the ruling, motion for rehearing about his subsequent taking of retirement benefits, but the judge, I guess, refused to take that into consideration.
I'm so sorry, but I could not hear you.
In a motion for rehearing, if I'm correct, someone tried to point out that the husband was now receiving his state retirement benefit. Is that correct? But the trial court would not use that to reconsider its.
I believe the wife attempted to reopen the evidence, and the judge did not want to hear that.
Okay.
The wife did not cross appeal that issue. So we're still stuck. This case has had a torturous history from the beginning of when they first even got divorced. It took them 3 times to get an actual final judgment and years to get a final judgment entered. As you can see, this case has been up here before and got kicked out right before oral argument because the court decided that the final judgment was not final. And we had to go back, and the court entered another order saying, no, I meant this to be final. So this is...
Let me ask you another question on the numbers.
Okay.
His monthly income seems to me that he's listing it as a gross number. I'm wondering where in the record I can find what his net income is.
Well, my understanding...
Or is it because his retirement benefits are not taxed?
That's my understanding, is the majority of his income is non-taxable because of the nature of it.
Okay.
But I'm not a tax expert, but that's my understanding is why it's listed as gross. And that there isn't a lot of taxable income that he's receiving at this time. But he's also not receiving a lot of income, and he does not have the ability to support himself and to pay this alimony. And the biggest thing is that the court erred by not conducting a 61.082 analysis. The court did not look and see that the wife's income has more than doubled. She's receiving her income has increased by $1,245 a month, while his income has decreased by $2,638 a month. So
there's nothing, correct me if I'm wrong, there's nothing in the record that suggests that investing in the fish camp was a wise or unwise investment decision, is there?
It was there. It hasn't been profitable, but he's gotten 2 5-star reviews. So they're hopeful that he will make income in the future. But no, there was nothing in the record to show that he did it out of spite or to avoid his responsibilities. In fact, the court found in the affirmative that there were good reviews and that he's hopeful that it will be profitable. This man literally went out and knocked on all the doors the court found. He looked for a job. He could not find one. He is considered at least 70% disabled. He's had heart attacks. He's been in motorcycle wrecks, and he has just not been able to find comparable employment. He had a good job with the Hillsborough County tax collector's office. He's not been able to find anything comparable. My understanding is his job was taken and split up in between 3 of his peers. So his job was eliminated, and he can't find, there are not a lot of taxing jobs out there, I guess. So he had to create his own job. And this is a camp that he's been going to this camp for several years, decades is my understanding. And he thought he got a very good deal on it. He borrowed some money. He used his all of his savings, and he sold his boat even so he could invest in this property. So if a man's going to sell his boat, or anyone going to sell his boat, if I was going to sell my boat to invest in a property, you better believe I'd believe in it and hope to be making a living off of it. So, he's done everything, and he is trying to support himself with this investment property. He didn't do it to just, live there. He did it so he will be able to make money off of this venture. And that's what he testified to. It's just not been profitable. If it is profitable, now that is the reason why there should be an alimony award of $1. So if it does become profitable, we don't know what's going on now with this virus. This might be one of the most profitable businesses going on right now or in the next 5 years. A fish camp that has 6 RV places, 6 cabins, and fishing areas, that might be a hot spot. If you award $1 permanent alimony, and this place is a hot spot to go live, she can move to, and he's making a lot of money. She can move to get an increase, to get it back up if she needs it. But right now, the most that she needs is $255 to meet her needs. her stated needs, and this is the first argument, which now I realize should have been my second argument in my brief, but her stated needs are only $223 gross per month. She stipulated that her needs had not changed. She has a very modest lifestyle.
But well, her numbers, her expense numbers went up from roughly 2,000 or 3,000 to 3,300 or something. There was a $200 or $300 delta in her expenses.
Well, she's on the record. They said that they didn't go up, and that's what was found in the final judgment. And
well, the judgment said they had not substantially changed. Or something to that effect.
Something to that effect. It actually said she stipulated that they hadn't changed. I can read it to you because I read it right before I got on here. So it said that stipulated that they hadn't changed. But regardless, she still is receiving in an amount excess of what she needs. But the bottom line is he doesn't have the ability to pay any amount right now. He may in the future, especially if this fish camp becomes profitable, which it may in these crazy times with, murder hornets and viruses. But the court clearly did not do its legal duty that was required under 61.08. I really like the Buxton case that I cited, it's a support case. It's a case where a supportive relationship case. But in that case, it talks about there are two sections of 61.08 factors that always seem relevant in both an original award and any modification. And one is D, the financial resources of each party, the non-marital and marital assets and liabilities distributed to each, and G, all sources of income available to either party. And in this case, the court didn't look at the income or the assets available. She has she has a house that's paid off in South Tampa, completely paid off, or a condominium. So she no longer has a mortgage payment. She has approximately $70,000 in liquid assets that's also generating her some income. But, number one, he doesn't have the ability to pay. So you've got to look at his income. Also, you've got to look at there was a case this past year called Will v. Will, which I'm very fond of because it's one of my cases. And in that case, it was written by the lovely Judge Kelly. It says, in calculating the appropriate amount of alimony, the trial court is obligated to consider the former husband's living expenses when determining his ability to pay. And here, there was no calculation of what his living expenses are. There was no calculation of what his ability to pay is. It just wasn't done at all. So there was just a complete legal error on the trial judge's part, because after a qualifying substantive change in circumstances is proven, the court has to apply section 61.082 factors, which is need and ability to pay. So since the court found there was a substantial change in circumstances, you've got to do need and ability. And it's just clear error on the court's part. Also, the modification should have been retroactive to the date of when the event occurred, which is when he lost his job. That's when he was entitled to that relief. And instead, the court did it to the date of when the former wife started receiving the Social Security benefit. So that's another, that was an abuse of the trial court's discretion. So these are the errors of the court that we're seeking to have reversed.
Very good, Ms. Purdy. You have your 15 minutes of rebuttal time. I'm sorry, 5 minutes of rebuttal time left.
Do you have any questions for me? Any more questions of numbers or? No?
All right, we're all set. Mr. Cunningham?
Okay. Thank you, Your Honors.
Yes, Your Honor. Good morning. Good morning, counsel. My name is Thomas Cunningham. I am counsel for the former wife appellee. I was her counsel during the original trial, and I was her counsel during the original hearing on the former husband's supplemental petition to modify. At the final hearing on the former husband's modification petition, the husband had not kept his job. There was questions asked at the hearing about what he had done. Despite that, the judge said that he had made a reasonable effort to find a job, even though he had not filed any applications, and testified that he had simply called people that he knew in the county from his years at the county to see if there was anything opening up. At the trial, the former husband used a legal principle as one of his, a faulty legal principle, as one of his bases for his inability to pay alimony, which had originally been set in the November 27th final judgment and amended due to other issues later on. He argued throughout the trial, including in his written final argument and again in his motion for rehearing, that not only could the present judge not consider his income from his military retirement and from his VA disability benefits, but that the judge who entered the original final judgment probably erred in considering those benefits in drafting that original final judgment. The former wife cited Acker versus Acker, a Florida Supreme Court case from 2005 that clearly set forth, every time this argument came up, that was submitted. It clearly showed that the trial court could consider income from all sources in determining one's ability to pay. Acker had clarified Diefendorfer versus Diefendorfer, stating that the proper method of determining one's ability to pay alimony would be to determine the various sources of income after equitable distribution, but not before. Thus, it would have been error only if the court considered his entire military retirement pay as a source of income, despite paying 35% of it, or $700 some odd to the spouse. This court did not do that. Likewise, the spouse's needs must be measured and based upon that spouse's financial situation after the equitable distribution. Therefore, the husband's reliance on a faulty legal principle I suggest that it's misplaced, that the trial court was correct in using both the military retirement actually received by the former husband, as well as, excuse me, the VA benefits that he received. If you look at the trial court's order issued on December 23rd, 2015, on former husband's motion for rehearing and former wife's motion for rehearing, the court set forth a clearly defined statement showing that it could in fact do that, and that the husband's arguments were not correct, both as to the retirement benefits and as to the VA benefits.
Even if we count those as income items, if his numbers are accurate, he's showing a couple $100 deficit between his income and his expenses. Isn't that correct?
Well, yes, and that makes it all the more interesting when you find out that he cashed in a deferred compensation policy, a deferred compensation plan that he was awarded. We're not disputing that at all. He was awarded a deferred compensation plan in the original final judgment. At the time, it had about $11,000 in it. By the time he retired, it was up to $140,000 because he was fortunate to have a job that had increased his salary post-divorce from approximately $45,000 a year to over $100,000 a year. And when he lost that job, when he retired from that job, voluntarily or involuntarily, he had this compensation plan that now had $140,000, $150 some $1,000 in it. He cashed it in, paid a significant amount of tax for turning it in or cashing it in according to his tax returns that were filed as evidence, and spent it on a virtually bankrupt business that he had been fishing at for decades, as his counsel said. And he testified that the gentleman told me he was going to lose the fish camp. Were you interested in buying it? And he said, yes, I was. In regards to his health issues, there was never any medical documentation. It was him simply saying that he had a heart attack. There was no indication as to how severe that heart attack was, whether it laid him up, put him out of work or anything. What he did have was a motorcycle accident that put him out of work for about 6 or 8 months. And he took money that he could have invested into a recognized investment plan and drawn income from that investment plan. Instead, he essentially went out and bought not only did he buy a $260,000 piece of property that he wanted to turn this bankrupt fishing camp into a going concern, but he put $100 and some odd thousand down on it and incurred an additional $1,158 per month mortgage payment by buying this camp.
The court's findings don't necessarily help you, because there's no suggestion that that was a waste, an investment was intended to avoid alimony. And the judge also apparently credited Mr. Lambden's testimony about his health conditions.
I agree.
So,
I cannot argue that point in there. I was just clarifying that he would have had extra money for income had he left his deferred compensation plan in the program that it was in. It would have kept paying him money. But in addition, on the date of the hearing, it was his birthday. I forget now whether it was his 62nd or 63rd, but he testified also that he could not start drawing his Florida retirement system income because his then current wife and he were going through divorce and she wouldn't sign off on it. And that's why I filed at a later time, once the original appeal had been dismissed for not being final, spent months trying to get, this judge had been transferred from family law to another. I spent months trying to get the new judge to schedule us a hearing in order to finalize that. And we finally got it back in front of Judge DeZerton, who was at the time, I think, sitting in criminal court, but he heard our case because he had heard the evidence in the hearing. And I had filed a motion, you alluded to it earlier, I had filed a motion stating that the former husband had started drawing his Florida retirement system amount, and I'd like to know how much, because that was not included in his computations for the husband's income because he had delayed taking it. Now,
so if we were, Mr. Cunningham, if we were to reverse, it seems at that point the trial court would have to consider what I understand is some $1,900 in additional monthly income.
It might even be more than that, Judge, because I'm not certain how his other divorce turned out, and I don't know what portion of it his wife got, but conservative estimate is that it's $1,900. Now, that's why I wanted the court prior to trial to determine that, because it is income before the case was actually final. It wasn't actually final until Judge Nazaritan entered his order last year sometime. And Judge Nazaritan said, nope, I'm not going to allow that evidence to come in. And I don't know exactly how much the former husband is getting from his Florida retirement system, but I believe that it's $1,900 or somewhat in excess of that. The other thing that I would like to talk about is how this faulty evidentiary principle that the former husband has continued to argue in his appeal. That faulty evidentiary is based upon the colloquy between Judge Nazaritan and myself at the hearing, whereas Judge Nazaritan in the beginning of the hearing was asking questions to get himself familiar with the lay of the land, what the case was all about. And he was asking questions of Mr. Manny, the former husband, and he asked questions of me. And the statement that was made was at page 33 of the transcript at the bottom. The judge said, so I'm assuming that you're going to, that you have filed a counter petition for modification of the final judgment. And before he could finish, I said, no, Judge, we haven't done that because the wife's needs are about the same as they were. Nowhere in the entire hearing did I nor my client stipulate that her needs were exactly the same that they were in 2000 when the original judge. The judge found she had needs of basic needs of $2,023. And that's the amount that the appellant has argued throughout the entire case. In fact, at the final hearing, my client's financial affidavit was introduced showing that her needs were $2,397, $98.27. So when you use her actual income numbers and need numbers, she had a deficit of more than what the judge reduced his alimony to. Not much more, but $25, $30 more, which I cited in my brief. For them to continue arguing that her needs haven't changed based upon a stipulation that didn't occur is disingenuous. There was a statement made that said they're about the same. The judge cited that in his findings in the order before this court. Now, that takes us back to the legal principle. In this order, the judge said, I previously filed a order on the husband's motion for rehearing and the former wife's motion for rehearing, and the husband's motions for rehearing are denied. In the final judgment, and basically he said that he could use the husband's military and disability benefits to determine, under ACCR, to determine his ability to pay. And in the final judgment, he said this final judgment, final order should be read in concurrence with my order entered on the motions for rehearing. Now, the problem with taking just a look at what the husband's expenses are is that he was spending over $3,100 a month, showing that much in his expenses. And to argue that his income doesn't even meet his expenses, you have to look at his ability, because certainly he would have other money had he not unwisely invested in that other money. Now, when the judge was asking me why we didn't file a motion to petition, a counter petition for modification of the final judgment. As the court is aware, such petitions must be based upon substantial unforeseen change in circumstances of the parties. It was clear that the husband was no longer making the $45,000 that he was back when the judgment was entered, but not only that, he wasn't making the $105,000 that he was making his last year at the tax collector's office, which he averaged over $100,000 a year, and his Florida retirement system would be based upon that average. As such, I didn't believe it was, I told the judge we had not filed a counter petition because I didn't think it was equitable for me to file a counter petition despite her increase in expenses, which were essentially the same, $375 difference, because by looking at the totality of the circumstances and because of her receipt of the Social Security payments that the spousal Social Security payments she was receiving, her income had increased, and we were fully expecting that her alimony would be decreased from the original amount of $1,500 awarded, and stated so in our final argument. For the husband to continue to argue that her stipulated that her expenses were the same as they were in November of 2000 is not only incorrect, but factually inaccurate and misleading. And finally, the court indicated that the appellant's expenses, that the appellant's expenses were at such and such a level. To me, buying the property and buying this bankrupt business was akin to going out and spending $400,000 on a automobile that he was not going to make any more money from that than he was from this bankrupt business. So his expenses were increased not only personally at home, but his tax return showed that he had received for 2 years over $35,000 per year in gross sales rentals for the areas at his cabin. And none of that money made his way into his home expenses. He continued to reinvest it into this bankrupt business that he bought. And as for his health conditions, we had a witness testify that at the day he was out there, the appellant was working on a backhoe trying to move large trees and other things that had fallen into his lake. So he clearly said he could not do his job at the tax collector's office because of his physical limitations, but he's doing manual labor at his other jobs. And unless anyone has any questions of me at this time, I'll see the rest of my time.
Very good. Thank you, Mr. Cunningham. Ms. Perry?
First, Your Honor, the Acre case, of course, the court is using the husband's military retirement income and disability benefits to determine his income, because that's all the income he has. So the first part of Mr. Cunningham's argument just isn't even an issue in this appeal. Number two, very importantly, the wife didn't dispute anything on the husband's financial affidavit. The charges are all reasonable. There's nothing extravagant on his expenses. He's driving a 2004 truck. So there's nothing extravagant that you can find on his expenses. It's under $3,200 a month. Third, the wife didn't appeal the order that denied the motion to reopen the evidence. So if this case is sent back, they can reopen the evidence, but it would have to be starting from the date of remand. It wouldn't go back to when this hearing was held. Would that be correct? That would be my understanding of the law, is the evidence would start from, if the court wanted to allow the parties to hear more evidence, it would start from the date of remand. It wouldn't go all the way back to the beginning of the hearing, since the wife failed to appeal the order requesting to reopen the evidence. The husband wants the decision to be made on the evidence that's already been presented, as to he has presented this, they've had the hearing, here's the income, this is what we have. We have a determination of what the husband's income is. We have the financial affidavits. He makes less income than he has in expenses. He does not have an ability to pay. So the alimony award should be reduced to a nominal amount. That's what this court should find. There should not even be a remand hearing. This court is correct. I apologize, Judge LaRose, and I apologize to opposing counsel also, because you're both correct that the finding in the court is number 13 on page 19 of the judgment. It says, number 13, it says, the former wife stipulated that her needs have not substantially changed. I apologize. I have sort of taken liberty with that and said they had not changed at all. So I got a little carefree with that, but they have not substantially changed. So you're correct. There's not been a great change in her needs. I still think the alimony award is excessive based on her current financial affidavit. I think she's still awarded too much alimony. But the bottom line is, in this case, there is no ability. In this case, there was no 61.082 analysis done after clearly there was a substantial change found to require the need and ability analysis to be done. Even if there is a need, there is no ability. He cannot meet his own needs. Regarding the purchase of the fish camp, maybe not the wisest financial decision, but we do not punish people. We do not make people stop living their lives and living the American dream of being your own business owner because you have a financial.
Ms. Perry, the court found no wrongdoing in that.
Right.
So I think we understand that issue.
So the bottom line is, the record is clear, just as if there's a case, I think it's Will, and it says, no, it's Voda. Hold on one second. It's the Voda case, and this is important because it says you have to make a determination of alimony, the ability to pay. And this is all cited in my failure to state such findings, the ability to pay alimony, can be harmless when we can determine from the order itself or from the transcripts that such findings were in fact made. Okay? Even if the trial court did consider the former husband's ability to pay, we cannot determine such consideration took place. In this case, therefore, we reverse for the trial court to determine the former husband's ability to pay while making the necessary specific findings. That's the Voda case. That's cited in my opinion. I also have, for the Will case.
You're about out of time, so just take a few seconds to wrap up, please.
Well, what's important in Voda, in this case, is there are no disputed facts regarding his income and his ability to pay. So instead of torturing these people any longer, this needs to be remanded for an award of nominal alimony. Else, this is never going to end.
Very good. Thank you, Ms. Perry. Thank you, Mr. Cunningham. If you will both leave the meeting, we are going to take a 10-minute recess before we resume with the last two cases on the docket. So we are in recess at the moment. Thank you.
Thank you, Your Honors.
Thank you.
Bye-bye.